Good morning, everybody. Can everyone hear me okay? Yeah, higher. Okay. Good morning. Thank you so much for having me. I'm so happy and honored to have been asked to speak with everyone today. And I'll be honest, before I was asked, I had absolutely no idea what your organization was. I'd never heard of it, and I must have driven past this building 1,000 times, and I didn't know you folks were here. So after learning about your organization, I took some time, looked at your website, and I am so intrigued by what you do here. I think sounds like a wonderful community that you have, and walking in here, I feel such positive energy, and I can see why you're all such longtime members. I think the shortest person I've spoken to has been a member for 12 years, which I think is really saying something about the community that you have here. So, as you said, I'm an elder law attorney right down the road. And when I talk about elder law, what I think that means is I'm usually thinking of, meeting not only with an individual, but really planning for their whole family. And I look at it as not this transactional thing, but really developing and building a relationship with clients, which is really what I enjoy doing. I found elder law really by accident when I was in law school. My school had something called the Elder Law Clinic. I had never heard of elder law. I didn't know what that meant. And I was really intrigued by it because I like the fact that, for the law, it's really not designed or intended to be this adversarial thing. It's really meant to be collaborative, work with individuals, solve a problem, and really avoid conflict, which I know is unusual for most attorneys, but it's actually what I enjoy most about my job. So when I'm talking about elder law, I'm usually talking about one of four things or one of four goals or tasks that I'm trying to help a client with. Who's going to make medical decisions for me if I'm unable to make those decisions myself? Who's going to manage my bill paying, my property needs if I'm unable to handle those things myself? What's long-term care? How am I going to pay for that? And then finally, when I'm gone, where are my things going to go? Where's my stuff going to go? And I want to make sure that I'm leaving things where I want it to go. So I often tell clients, because sometimes the first thing they'll say is, I need a will. But I really think the most important documents or things that clients can address is what happens if I'm alive, but I can't manage some aspect of my life. And, first up, I think, is having a healthcare proxy. So the reason I think that that's so important is in the absence of that, you're leaving to chance what's going to happen. And it's not just, end of life care. It's really about effectuating your wishes and effectuating your preferences. If you are unfamiliar with what a healthcare proxy is, there's a sample in the handout that's in front of you. And I really encourage everyone to think about not only what your wishes are and who you think the most appropriate person to handle those, but actually have a conversation with that person. So very often, a common conversation I have with clients is, well, I'm going to name my daughter because she's the oldest. But as we're sitting there and we're chatting, it's becoming very evident that this daughter has a lot on her plate. She's got young kids, she's busy with work, or maybe she's just very emotional. And the burden of being the one to make medical decisions, perhaps end-of-life decisions, may really be putting an emotional toll on this child that she may not be equipped to deal with. So just because someone is a child or is related to you doesn't necessarily mean that they're the most appropriate person to carry out your wishes. Because on top of it, they also may have different religious, ethical, political beliefs than you do, and what you may want may not jive with what their own belief system is. So I think it's not only important to have a plan, but have a plan that's, considering the values and wishes of the person that you want to be your agent. And even though these aren't fun conversations to have, they're really important. I can only speak from personal experience. As an attorney, sometimes I'll be appointed by the court to serve as a guardian. So I'm initially a complete stranger to this person. And for me, it's something that weighs very heavily on me. I don't do it often because it's very time consuming, and because if you're doing it correctly, it's something that should be time consuming. You're now tasked with making a variety of decisions for this person, this person that you may not know. So I'll give you an example. A number of years ago, I was appointed as a guardian for a woman who originally came here from the Philippines and had been living here for a long time. She unfortunately suffered a pretty severe stroke and ended up in a nursing home. She had no local family, so I, as an attorney on what's known as the Part 36 list, was appointed as her guardian. And while she had originally spoken English, because of her cognitive decline, she had reverted to her native language, which I did not speak. So communicating with her was incredibly difficult. And because of her cognitive decline, I was never able to have conversations with her about her end-of-life wishes and preferences. About a year ago, on a Saturday morning, I got a call at 6 a.m. that she was admitted to the hospital because she was suffering from an infection and she was declining very quickly. And she was in ICU, she was on life support. Thankfully, she had a family that she had worked with for a long time that she was very close with. She would celebrate holidays with them, and the sons were able to come to the hospital. But at the end of the day, the decision was mine to make about whether or not to remove life-sustaining treatment. I asked the family, I'll call her Jane. Did Jane ever discuss this with you? Did you ever have these conversations with her? And they didn't know. It was something that never came up in their regular. I located family of hers in the Philippines, but again, it was something that hadn't come up. So she was on life support for a number of days, and I would speak with a variety of doctors, specialists, nurses, and I would say, if this was your mother or your grandmother or your aunt, what would you do? And it was something that, like, even now I think about it. So I say that not to be morbid, but just to really impress upon you if, at the end of the day, we're all going to unfortunately pass away at some point, right? And we never know when that time is, what the circumstances will be. And very often, a family member, a loved one is going to be left with either making really, really tough decisions or, effectuating our final wishes. So as someone who's been in that position, I wish that I would have had actual knowledge of what Jane's wishes were. I feel like I did the right thing. I feel like I took it seriously and I weighed it, very seriously, but I wish I could have had a conversation with her about what her wishes and preferences were. So, something in looking at your website that really resonated with me was basically everyone's entitled to live a life of dignity, right? And I think at the end of the day, if we're incapacitated or we're in, a compromised situation, I think we all ultimately just want to be treated with respect and dignity. And I think that's something that you can very affirmatively do simply by having very simple plan in place and making sure that the people that are going to be tasked with making those decisions knows what your wishes are. Coupled with, a healthcare proxy is often something called a living will. This is sort of, in line with what I'm talking about. Funny enough, New York actually doesn't have a living will statute, but lots of clients will still have them. And what a living will is, not to be confused with a last will and testament, it's really like a set of instructions or guidelines or your wishes that really sort of acts, more as a tool for your healthcare agent. So that's another way that you can sort of make sure that your wishes will be carried out. Related to healthcare decision-making is who's going to manage my stuff, my property, paying my bills, my insurance, all that fun stuff, if I can't, handle those things myself. And this, I'd say, is one of the more important decisions that, you as an individual would have to make. You're giving someone potentially a lot of power and control over your financial life. And again, just like I was saying before, just because someone's your oldest kid or lives close to you doesn't necessarily mean that they have the skill set or the wherewithal to be the most appropriate person to carry out those jobs. There's another sample of a power of attorney in your packet, just so you know what it looks like, and you'll see there's a list of things or tasks that your agent can potentially do on your behalf, and it's a lot, right? And I think, again, it's also making sure that the person who you'd want to carry out those things is up for the job. This is a little different. Your agent, before they can act, has to affirmatively acknowledge and accept their role, unlike your healthcare proxy. So here, at least they'll know that this document exists. But, if your agent's someone that lives far away or has a very demanding job, if you're truly incapacitated and this person now needs to step into your shoes and handle your bill paying, your insurance, your day-to-day needs, is potentially a big job. And maybe it's something that you want to split up with two people. And maybe your spouse or your kids, again, are not the most appropriate person. Maybe it's your nephew who's, a financial advisor. So I say this to say that you have a lot of control and autonomy over who these people can be. It doesn't necessarily have to be just a blood or legal relationship. It has to be somebody that you're comfortable, stepping into and handling these things on your behalf. And something, that comes up for me a lot as an estate planner is, who's my client? And that's always a big consideration. So it's not uncommon that we'll get calls from adult children. Oh, my mom wants me to be her agent, or my mom wants me to be her power of attorney. My mom wants to make a change. And that's great, right? But your mom has to call, your dad has to call. And as much as you want to give every individual the benefit of the doubt and assume that their intentions are good, it's always very important to me to make sure that I'm dealing with the person that's actually my client, and what I'm preparing is what this person wants. My job is unfortunately not to make, the adult child's life easier. It's to make sure that the person who's creating the documents, this is something that they want, that they know what they're signing, and that they're not being, unduly influenced or pressured in some way to create a specific estate plan. Another big part of what I do as an elder law attorney is, planning for long-term care, and making sure that folks, as much as possible, are able to live out their life with the highest, quality of life possible, and ideally in the setting that they prefer. It's not always possible, but that's all we can do is plan and hope that we can carry out what their ultimate wishes are. So, a lot of my clients are just regular middle-class folks. They work really hard to acquire whatever it is that they acquired, and they want to make sure that it's there for them to use and enjoy for the rest of their life, but that they want to make sure that they can protect it and pass something on to their children, when they're gone. So when I'm talking about long-term care, I'm usually referring to someone who requires assistance with their activities of daily living. Someone that needs help getting dressed or bathing, all the things that we do throughout the day to get through the day safely. If you need help with one of those things on a regular basis, that may be someone who needs some type of long-term care, whether it's, temporary because they just had an accident or something, or on a more long-term basis. So a big part of my job involves counseling clients and informing them about what their long-term care options are, how they finance that, and if they're looking to something like the Medicaid program, which I'm sure a lot of you folks have heard of, it's helping them become eligible for those programs while also preserving the assets that they worked really hard to acquire. And then lastly, when we're talking about elder law, very often we're talking about, I have this stuff and I want to make sure this stuff goes where I want it to go when I've passed. The most common way, or probably what most folks have heard of, is something called a last will and testament. And that's essentially a document that controls assets that are in your name alone when you pass away, that do not have a joint owner and don't have a beneficiary. And for a lot of folks, this is a great tool to plan because maybe you're concerned about or you want to include minor grandchildren or someone that has a disability, or maybe someone that you want to benefit them in some way, but you know that they maybe aren't financially savvy or they may make bad financial decisions. So, part of my job as an estate planner and an elder law attorney is not just, writing down what someone says and making a document. It's making sure that they understand the consequences of certain choices. And we very often think of it more as intergenerational planning. So where someone's in front of me and they have a particular question or concern that we're trying to address, but it's also making sure that their family as a whole, that their needs are being met. And something else I spend a lot of time with clients talking about is, what their wishes are, and there's equal and then there's equity, right? So sometimes clients will say, I want to leave everything down the middle to each of my children, 50-50, great. And sometimes clients will come to me and they'll say that my son is very squared away and he does very well financially, so he doesn't need my money. But my daughter has young kids and, she hasn't worked because she was raising her children, so I know she'll need the money more, so I'm going to give her a larger share. And I always really try to strenuously tell them, that's fine, it's your estate plan, you can leave your stuff wherever you want to leave it. But I always try to encourage folks to make sure that their family understands the rationale for why they're doing certain things. Well, I don't want to make my son upset. Well, if he's upset while you're alive and you're telling him, how do you think he's going to feel if he's finding out after you've passed away? And even though it's a completely rational, reasonable choice, very often estate contests aren't about the money, right? It's about emotion, it's about so many other things, and family dynamics, as everyone in this room knows and on Zoom knows, family dynamics are so layered and complex, and very often when I'm dealing with, adult children now, and maybe there's some strife or there's some disconnect, and it's, how were you guys when you were kids? Oh, we were best friends, but then he got married and I got married, and the in-laws, play a role and kind of change the relationships and dynamics of family. So, if I leave you with nothing else today, it's really just, I always try to encourage families, please, please, maybe not something you want to discuss at Thanksgiving, but definitely something that you want to have these conversations with your family when you're here, and you can take some of the pain and emotion out of it and just let your family know why you're making certain choices and certain decisions. Because I think, anyone that's a parent or has loved ones, I would assume that your ultimate goal is that when you're gone, that your family is still going to have a relationship, and there's still going to be cohesiveness, and there's still going to be love, and there's still going to be family time and new memories. And very often when I'm dealing with someone where there's an estate contest, I think a lot of the problems could have been resolved had there been more of an understanding, while the parent was alive. And it's really, really heartbreaking. And I'm one of four, and I have three brothers. We're very close. We have a really, really good relationship. And, I did estate planning for my parents. And the first thing I did was I said, we're all having a meeting and we're all having a conversation, and we're all on the same page, because at the end of the day, we're not ever fighting about stuff. We're not ever fighting about money. And my one brother, Sean's response was, let me get this straight. If God forbid something happens to mom and dad, you're going to do all the work and we're going to split everything equally? He said, yeah, I'm good with that. Yeah. So, but I think it's more just, I think people fighting over stuff is really one of the saddest parts of my job, is seeing families. I had a mediation last week, and it was two brothers, and they're literally fighting over what amounts to be a couple of $1,000s. And we're at the end, we're almost there. It's been a very contested estate, and I left there and I had such like a heavy drive home. I didn't even put on my true crime podcast like I usually do when I'm driving home. I just sat in the car in like absolute silence back to Queens after I left the office, because it was just so like sad and heavy. So, a lot of my job is like I'm part attorney, but part family counselor and part therapist. And it's something that I think you, as, individuals maybe thinking about your own estate planning and things like that, I think that's one thing you can affirmatively do to leave your family in a better position. Your stuff's going to go where it's going to go, right? But you also want to make sure that you're leaving behind a family unit as the best you can. That's pretty much all I have. I wanted to leave plenty of time for questions. So, if there's particular questions about elder law, estate planning, I'm happy to answer them. I didn't want to just lecture you folks. I really just wanted to kind of give you a sense of who I am and kind of why I love what I do, because I really do enjoy it. Yes.
This is a very specific question.
Sure.
In New York State, what happens to a person's body? Who owns it or can enforce what happens to it? Like, for myself, that's been resolved informally. My body will go to medical science, but who determines and how is it enforceable?
So you bring up a really good point, a really good question. So ideally, it's your legal next of kin, right? Unfortunately, someone passes away, their body is at the hospital, and then a spouse, an adult child will make funeral arrangements. But when there's discord and there's disagreement, it's definitely in flux. So some folks will put their disposition wishes in their will, but I don't think that that's the most appropriate vehicle, because if you think of it from a practical aspect, when you pass away, that's when your will takes legal effect. But it doesn't really have any legal force until it's actually submitted to the surrogate's court and it's probated. And the court will issue something known as letters testamentary, which is like a piece of paper. And that's what empowers your nominated executor to carry out your wishes. So, in an emergency, you can try to push it along, but that process can take weeks, if not months. Meanwhile, you're kind of just hanging out, right, in the morgue. So I would say if you have very specific wishes, one of the nicest things you can do for your family, I know it sounds very morbid, is prearrange your funeral. And that way, you personally have gone to the funeral director or the institution where you're going to be donating your body for research purposes, whatever your wishes are, whether it's cremation. Now they have things which actually sound very interesting, where you are kind of turned into like a tree. So there's so many different options that people have, and I would say that's the most straightforward, easiest way. In the absence of that, there's your legal next of kin, your last will and testament, and there's also a document that is specific to the disposition of your remains. It's almost like a healthcare proxy for after someone's passed away. So there's a variety of ways that this gets taken care of, but that's the long answer to your short question. Yes, sir.
Which do you consider a stronger document, a living will or a revocable trust?
So I would say it depends. Oh, sure. So his question was, what do you think is a stronger document, a living will or a revocable trust? So is this about your property, or are you talking specifically about medical decisions? Property. So a living will, I think you meant a last will and testament, because a living will is a document that's really like an accompaniment to your healthcare proxy. So it's a great question, and I would say it really depends on what your goals are. So what a revocable trust is, for folks that don't know, it's basically this empty shell that you create while you're alive, and you fund it with property. And how it gets funded is you retitle assets into the name of your trust. So as an example, I've created this revocable trust, and I'm going to retitle my home into this revocable trust. So now it owns my house. And a lot of folks like the revocable trust over a will, because the revocable trust will avoid probate for assets that are owned by that trust. So if you're someone that has property in more than one state, or you're concerned about maybe someone contesting your will, or you just said, I dealt with it with my mom's estate and it was a nightmare, I want it to be easy for my kids. For some folks, they would prefer the revocable trust. And the last will and testament, I think, is still a really important document. It gives you the flexibility to do certain things like estate tax planning, if you're concerned about that, or if you're planning for someone that has a disability or someone that's a minor. You can create trusts in your will. So when I say what's stronger, I would say a revocable trust is harder to contest or harder to challenge. The probate process, by its nature, basically involves the person who's the nominated executor. There are certain people they have to obtain jurisdiction over, which means they have to notify them. So even if your will leaves somebody out, certain family members are still entitled to be notified, even if they're not a named beneficiary of your will. And because there's this automatic right they have to be notified, it can make it very easy for them to challenge. A revocable trust, on the other hand, there's no notification requirement unless the person's a named beneficiary. So if someone was cut out of your estate plan for whatever reason, and all of your assets were titled in a revocable trust, it puts the burden on this person who's cut out to seek it out and challenge it. So I would say, if that's what your question was referring to, probably a revocable trust. Yes.
Just a question. Are there any implications for a financial power of attorney if they're out of state? I've designated son, he's out of state.
That's a great question and a very common one. Because so many things can be done online now, I don't think the distance restriction is what it was even 10, 20 years ago. There's no requirement that someone be physically located in the state of New York. It might make more practical sense in some cases, but because so many things, even if you personally don't do online banking, if you're unfortunately unable to manage your bills and your son lives out of state, he can actually do a lot of your bill paying online from wherever he's located, even if he's located out of the country. And actually, when it comes to your estate planning documents, there's not even really a restriction on someone being a U.S. resident, with the exception of someone who's a nominated executor. So someone who's an executor has to at least be a U.S. resident or be serving with someone that's a U.S. resident or citizen. But anyone who's your healthcare agent, power of attorney, trustee, there really is not a, and I often have clients, who have agents that live out of state or out of the country. Usually the biggest kind of pain to deal with is just getting their agent acknowledgement notarized. So if they're living abroad, that's usually the biggest headache is just, but now they even have remote notaries. So even that's less of an issue than it used to be. That's a really common question. Yeah. Sure. Does anyone on Zoom have a question? No? Okay. Yes.
Thank you. And thank you for your lovely framing of this. I feel very, I like you. No, but you're exactly the kind of person I would want to help myself, my family, go through this type. I love the compassion that you've exhibited, but that's not my question. My question is that I have heard in various people talking about difficulties if one person is named as the power of attorney, the financial power of attorney, you know what I'm going to say, and the other person is the healthcare proxy, and the difficulty if those two people are different.
Yes. And I think this is actually probably one of the most common conundrums that clients face, and it's always so fascinating to me that children can be raised in the same household and they grow up to be completely wildly different personalities, human beings, how they perceive the world. And it's so funny because it's like you're close in age, you had a very similar upbringing, and it's hard, and I think there's no clear answer, but when I'm, talking to clients, part of what I like to do is really, especially if they're having doubts about who to name in a particular role, is really talking it through with them and giving them real life examples. Okay, so you're in the hospital, you can't speak for yourself, you're naming this person. Do you think that they're going to have the emotional bandwidth to carry out your wishes? Maybe not. Maybe that person is better suited for cut and dry, paying bills, managing money. But it is interesting because very often some kids don't have any interest whatsoever in being a decision maker, and then other times all the children are jockeying for who's going to be in control. With the power of attorney and financial decision making, you actually have a little bit more flexibility because you can have more than one person who's authorized to act at a given time. And even then, you have the choice to require them to act together or to allow them to act separately. And there's pros and cons to all those choices, right? With the healthcare proxy, it's a little different. You can only have one person who's authorized to act, but I'll always tell clients, and sometimes clients will even put in their instructions, is that wherever practical, they want their agent to discuss this with the rest of the family. But the healthcare agent is only one person, because if a doctor is looking at a family and they're all yelling different things, there's one person who's going to be the decision maker. But with a power of attorney, if you have two kids that you trust equally, you can name them both to act. And if you think they're both going to do the right thing, you can allow them to act separately. And that way, as needed, they can kind of act and support each other and help each other. But it's a really good question and it comes up a lot. And unfortunately, there's not like a a clear answer. So what I try to really encourage clients to do is think about, you know your kids better than anybody. Who do you think is better suited to do a particular task or to serve in a particular role? And sometimes it's not their kid at all. Sometimes it's a niece who's a nurse practitioner and she's, you know, emotionally equipped to deal with the, you know, medical decisions. And sometimes it's the nephew who's, you know, a CPA and very squared away and they trust implicitly to handle their money. But I will say a power of attorney is not just about money and bill paying. It's, you know, the person who's ultimately going to have a lot of say and control over where you receive care if you need to, because at the end of the day, it shouldn't be like this, but it's all about money, right? And where your money is and what kind of money you have and the insurance coverage you have and all of that. So on the one hand, you know, when you think of money, it's a little bit more emotionally detached. But in this case, when you're talking about long-term care planning, you want someone who's also going to be compassionate, and you want someone that's going to think about your quality of life and carry out your wishes. And sometimes it's, you know, I want to be in a particular long-term care facility. I don't really want to be, but I want to be somewhere that, you know, maybe I have very strong religious beliefs and I want to be in a facility that's going to offer religious services to me or allow someone to come in and, you know, give me communion every Sunday. So again, I think it's really just about having those conversations with your family is the most important part. Yes.
I was wondering if you could say a few words about how New York State looks at people who are shielding their assets for Medicaid. I know the look-back period has changed from 36 months to 60 months, but you probably have a lot more to tell us.
Yes, absolutely.
Thank you.
No, it's a really good question. So yes, so there's a 5-year or 60-month look-back period for nursing home coverage, which basically means if today was November 1st and I was in a nursing home and I wanted New York State Medicaid to pay for that care, I have to go back to November 1st, 2019. And I'm basically giving Medicaid all of my financial life for these past 5 years. And what they're looking for is, have I given money away or transferred, gifted in those past 5 years? Because if I have, their presumption is that was for the purposes of qualifying for Medicaid. It may not be the case, right? You can always rebut that presumption. You know, if you're giving money to your grandkids every year for their tuition, or you paid for your daughter's wedding or something, that was not necessarily in contemplation of planning for Medicaid. The other big Medicaid program in New York State is community or home care Medicaid. So traditionally, there has never been, or not for many years, a look-back period for community-based Medicaid. So what does that mean? So today is November 10th. That means that, let's say I had $100,000 in my name. That's too much money, right, to qualify for Medicaid. If I gave that to my best friend tomorrow, that means as of December 1st, if I meet all these other requirements, I could technically be eligible to qualify for community Medicaid, even though I just gave away all this money. So because New York State recognizes that you can very easily divest yourself of money and get services, every year they're always threatening to make it more difficult to qualify for specifically home care Medicaid. So back in 2020, actually, when New York State did its annual budget, they said, that's it, we're going to start imposing some restrictions, and they said they were going to impose a 30-month or 2.5-year look-back period for community-based coverage. All elder law attorneys were scrambling. It was supposed to happen October of 2020. But the can keeps kind of getting kicked down the road, and it actually hasn't gone into effect. There's been a couple of other, you know, changes that they've discussed. One of them was actually at one point discussing getting rid of the resource test entirely. And the thought process behind that was actually New York State thinking it would be more equitable to do that because they saw a disproportionate way that different communities access the Medicaid program. So certain assets are exempt for eligibility purposes. The value of your primary residence, any assets that you have in a qualified account, like a retirement account, a 401k. And they recognize that minority communities did not have the same resources like this as white families, basically. So they thought that it was, you know, why should someone who owns a home and has a retirement account be able to qualify for Medicaid when someone who has equal value assets, but they're just in a savings account, but they're ineligible? So they toyed with this idea of getting rid of the resource test, but it hasn't happened. So New York State is certainly keenly aware that people are sheltering assets. So I look at Medicaid planning like it's a puzzle. The regulations are the regulations, and each family is very different, and it's trying to fit that particular family into the puzzle so that they can preserve some assets, and they're also getting the care that they need. And one thing I'll say, I don't look at, asset protection planning and Medicaid planning like, oh, let's hide this from the government. I really look at it as, it shouldn't be like this, but the more money you have, the more options you have in terms of, paying for care. So if you can have this little pot of money on the side that's there for your benefit, it just gives your family more options to pay for additional services, additional hours. If you're in some type of facility, they can have a one-on-one companion. So the benefit, I think, of doing the, estate planning and the Medicaid planning is that you're kind of just stretching your money out further than if you were spending everything paying for your care and then applying when you had nothing left. So it's, kind of to be determined how Medicaid looks in the next year, 5 years, 10 years. But, we just try to stay on top of it and plan the best we can.
Kevin, is there, David, does David have a question?
Someone's hand was raised. Yes, David did. They have to mute themselves.
Alice, you have to unmute.
We have a guest who has a question. Hi, can you hear me?
Yes.
First of all, thank you. This is an exceedingly informative presentation. So I very much appreciate visiting Alice for this and catching at least the end of it. But here's our question. If you have a married son with children and you leave everything to that child when you pass on, both parents, and that child ultimately gets divorced, is that child's body of money, I guess you would call it, investments or the like, much of which might have come from your inheritance or his inheritance, is that divided as part of a divorce settlement typically, so that the spouse would really be winding up with half of your inheritance?
I think you just asked probably the most common question I get as an attorney. So the short answer is no. So if your children, which is everyone's goal, right? If all of your children survive you and now your estate gets divvied up however you've directed, and your child takes that money, an inheritance is not considered a marital asset. But the big trick, at least in New York, the big trick though is that your child can't commingle that money with their other marital assets. So if your kids are aware, I know, and whatever the relationship is, right? But if they take the money and they leave it separate always, and they name your grandchildren or other people as beneficiaries, and your child later unfortunately divorces, that money is not going to be considered as part of a dissolution of their marriage and of their assets. If they take some of the money and they, put a new roof on the house or they pay off the mortgage, that's a little different. And that's harder to, avoid it being tied up in a divorce proceeding. So what I would say to your kids, if something happens to us and you inherit money, our hope or preference would be that at least part of this is kept completely separate so that if you later unfortunately divorce, which I hope you never do, we want the money to stay in the family. We don't want it benefiting our ex-in-law child and their potential future spouse.
Right.
That's a question, I get it a lot.
Okay, and that would go for investments too, if your child were to purchase a second or third home?
Well, it depends on how that, if that asset is, if the new investment property is titled in your child's name alone, then yes. If they take that money and they add their spouse as a joint owner, then no, they've essentially
Okay.
taken half the money, yeah.
Okay, terrific answer, thank you.
Yeah, no worries. Yes, sir. One more, okay.
Very clear.
You mentioned that there's a 60-month look back And then you mentioned that there's a 2.5-year look back.
Sure.
I don't understand the difference.
Yep, so sorry if that wasn't clear. So the 60-month or 5-year look-back period applies only to nursing home coverage, and the 2.5-year or 30-month look-back period would, if it goes into effect, would apply only to home care or community applications for Medicaid. It's not in effect yet. So the only applicable look-back period that we have right now, if someone is seeking Medicaid, is the 5-year look-back period for nursing home coverage. That make more sense?
So the 2.5-year would potentially be for in-home care?
Exactly, yeah, so his,
Being spent for in-home care?
exactly, so his
Give
question,
away $30,000 today.
mhm.
December 1st, if this was in effect, you would have no assets?
Well,
According to the law?
right, so if the 2.5-year look-back period was in effect now, right, and if you were applying for home care Medicaid, you were subject to this 2.5-year look-back period, you wouldn't be able to transfer money because you would trigger a Medicaid penalty period. That's what Medicaid's ultimately looking to do with any type of look-back. They're reviewing your assets, they're highlighting problematic gifts or transfers, and they total it up. And then what they do is they take that number, whether it's 30,000 or 100,000, and they divide it by the average cost of care in your county. And what the resulting figure is a length of time, whether it's 2 months or 2 years, where they're not going to pay for your care. So there's no penalty period right now for home care. So in your scenario, you could transfer $30,000 that's making you ineligible to your mailman. And on December 1st, you're financially eligible to apply. If you were in a nursing home, we'd have to be a little more creative with that $30,000. We can't just transfer it away. We have to do other planning with it.